Great. So welcome everyone, and thanks so much for joining us today. My name is Erica, and I coordinate the Institutional Grammar Research Initiative, also known as the IGRI. Our IGRI research seminars feature scholars from around the world who use the institutional grammar to examine the origins, structure, and implications of institutional design. And I'm very excited to introduce today's guest speaker, Dr. Gerard Conway. Gerard is a senior lecturer and professional liaison tutor at Brunel University of London, where he has taught law since 2007. His research focuses on legal reasoning, particularly of the European Court of Justice, as well as European Union institutional law, the interaction of EU law and international law, and the EU criminal justice system. So today he will be presenting on his research related to the study of commons. And with that, I will turn the floor over to you, Gerard. Thank you so much for presenting today.
Okay, well, thank you, Erica and Saba, for inviting me. As Erica said, I teach in a law school, so I have a legal background. And I came to be interested in the idea of commons through a research project studying the application of commons to space, and in particular, the idea that, or thinking about how tax might be relevant to space, how activities relating to space could be taxed, and the fact that such a tax seems to apply to situations or scenarios that are international or global or beyond the standard national tax jurisdiction. And the idea of a commons seemed relevant to thinking about how a tax might work in that set of circumstances. So, as I say, taxes typically take place within a national tax power, within the sovereign power of the state to tax. There are relatively few international taxes in the world, so commons. I became interested in commons through thinking about that issue and the idea of an international tax in particular. Okay, what I'm also interested as a legal researcher in legal norms and in the study of types of norms. And my PhD project, which I completed at Brunel University in 2011, studied conflicts of norms in legal reasoning. So the idea of norms seems obviously central to law and to legal thinking, but explicit discussion or theorizing about the nature of norms, the character of norms, is less mainstream within the study of law than you might think, than scholars in other disciplines might. For example, in your discipline in policy analysis, the express or explicit discussion of the types of norms and of the character of norms it's not that widespread because lawyers have working rules to engage with, to deal with. There are already legal systems that have developed over time and that are in place. And when you have legal systems are almost universal features of human society. When you have a working legal system, thinking about sort of conceptual underpinnings of working rules is not a practical necessity. So it's perhaps a bit surprising that the study of legal reasoning is, to some extent, a bit marginal to the practice of law and to even within the legal academy. So I was interested in the idea of conflicts of norms for my PhD project and studied the writing that there is on what's sometimes called jural relations, which is this idea that behind substantive legal rules, which, as I say, are actually in place, actually work across legal systems in the world, that there are standard forms of juridical or jural relations. And this idea, if you like, that there is a kind of a conceptual underpinning to all the different substantive areas of law that, as I say, take place on an everyday basis and are practiced on an everyday basis, is most associated with Wesley Hohfeld, a US academic who taught, I believe, at Stanford and Yale universities, especially Stanford, and he lived from 1879 to 1918. And he wrote a famous study, which Fundamental Conceptions of Legal Relations, which was one of the first attempts to try to explain the conceptual underpinnings of standard jural relations and to identify in a more abstract way, outside of specific areas of the law, the relationship between what you might call basic building blocks of legal reasoning or legal concepts. So the concept of a right, the concept of a liberty, the concept of a privilege, the concept of immunity, the concept of liability, how to think of a general or universal scheme of these basic building blocks and how they relate to each other. Hohfeld is widely respected still today, although he died quite young. He's widely respected still today for for this approach and this study. But it's, as I say, marginal in the practice of law and in how lawyers engage in their work. He's occasionally sort of referred to or deferred to academically, but this kind of conceptual study of types of legal norms is not very widespread. When I came across Ostrom's work and the idea of an institutional grammar, and I was reading more about commons, there seemed to be an obvious link with Hohfeld's approach. So what I tried to do in this presentation is to consider in what way a legal perspective on norm typology on the definition of norms is relevant to, can be helpful for considering Ostrom's institutional grammar. It's become most associated with Ostrom, so I refer mostly to her, but I refer in the presentation, refer also to other authors. One of the things I came across when reading in the area was that one of the other leading researchers in the field, Tina de Moor, and collaborators of hers working on a study of historical commons, used a different typology to Ostrom's, even though Ostrom's had become fairly well established. So what I want to do is consider how the two different typologies might relate to each other, and then to see what legal analysis might contribute to it. Okay, Ostrom herself was interested and made clear her concern with the idea of rule forms or rule types. So from my perspective, it might be easy to divide Ostrom's work into three aspects. Firstly, the what's now called abdico, the study of the syntax of rules, and the sort of the way in which that is used to code and to measure and to quantify legal rules in policy analysis. Secondly, there's the rule forms that Ostrom identified as sort of standard. So position rules, boundary rules, choice rules. And thirdly, the design principles of common governance, which she, if you like, inferred from in stepping back, if you like, from her many decades of empirical studies of commons and how commons worked. So I'm particularly interested in this presentation in the standard rule forms, not so much the abdico. I'll just say a bit about abdico, but in standard rule forms that Ostrom identified as sort of common to the practice of social rules in commons contexts. And there's a quote here from her, that the puzzle has been how to develop a language to express rules that enables one to capture in a consistent and cumulative manner the most general characteristics of the basic rules, while providing a structure that enables scholars to enumerate and test the impact of changes in a rule type. So the most general characteristics of the basic rules: all repetitive situations faced by human beings are composed of nested layers composed from the same set of elements. to be more confident that we have identified the components of a wide diversity of situations found in all sectors of organized life. So you could say that this is a search for a typology of universal forms. And that's exactly what was Wesley Hohfeld's concern in his study of jural relations. Lawyers tend not to use the term norms and rules in a very explicit or conscious way, in a way that's like that formally distinguishes them in the careful way that Ostrom did. So Ostrom identified norms as having the elements of abdico, except the absence of a sanction, and that rules, on the other hand, had consisted of norms plus a sanction. Now, as I say, lawyers don't sort of systematically distinguish between rules and norms in that way, but legal theory does focus on one aspect of law that is relevant to that distinction made by Ostrom, and that is the idea of sanctions as a general feature of law. But maybe surprisingly, there isn't a consensus within legal theory that sanctions are a defining feature of the subject. And legal theory hasn't, if you like, settled upon a sort of single neat definition of law relative to other kinds of rules. Okay, so I think that legal thought can be helpful for understanding rule types and social rules, but perhaps it's surprising that legal thinking on it is maybe not more advanced in some ways than the kind of work that Ostrom and her colleagues and other researchers have done in the area of commons. I would think that everybody who's attending this seminar today is well familiar with abdico, the grammar of rules. So I'll just say very briefly a bit about it. From a legal point of view, what's especially interesting is the deontic element within the attribute, or within the components of rules and sanction. So what kind of deontic element is or component is there in a rule, and what kind of sanction, or is there a sanction to it? And one of the ways in which law might be able to contribute to common scholarship is an understanding of the deontic aspect of rules. So that's one area where law might contribute. As I say, I'm mainly interested in this presentation, not so much in abdico, that element, but in the universal rule types that Ostrom identified in her, I say, extensive empirical studies. And these are the position rules, boundary rules, choice rules, aggregation rules, information rules, payoff rules, scope rules, and default condition rules. So from a legal perspective, what might be said about that kind of categorization? Well, firstly, they don't individually have a deontic element to them. They're more concerned with subject matter. What does the rule does rather than how does it do it in deontic terms. Some of the rules are more, if you like, general, relative to the idea of subject matter. So a position rule, a boundary rule, an aggregation rule, an information or a payoff rule, they can kind of connect more easily with a particular subject matter. Boundary seems self-evident, although in commons you think of physical boundaries, but there are other kinds of boundaries also. Aggregation rules are rules about who has authority at different levels of a system. Information seems clear, payoff seems clear. The concept of position is a bit more ambiguous. And I say a bit more about that because it seems to relate to what lawyers would call a competence or a power. In particular, position, boundary, and aggregation rules could be taken together from a legal point of view to convey what lawyers call power or competence. More recent legal scholarship has preferred the term competence, but Wesley Hohfeld himself used the term power to convey the notion of a capacity to change legal relations as a defining feature of a power relative to other building blocks within of legal concepts. So power is conceptually distinguishable from a right, which is conceptually distinguishable from a duty. But the concept of power, the capacity or the ability to change legal relationships, from a legal point of view, seems to capture those first three elements, or those first three rule types that that Ostrom identifies. Within institutional grammar, the deontic is applied to these universal rule forms through abdico. So abdico is standard across each of them. So just from that way of doing it, you can see that the institutional grammar, if you like, doesn't front load the deontic element to it, the deontic element of it. It's more concerned, I suppose, it starts off with a concern with subject matter. Okay, and you can see that in the way in which Ostrom identified types of rules and the aim verb associated with them. A position, the basic aim verb in that is be. Boundary is to enter or leave. Choice is to do. Aggregation is to jointly affect. So as I say, the deontic doesn't come through so directly in that way of categorizing rules. Regulating positions, the term position in particular seems, from a legal point of view, a bit ambiguous. A position could be a legal position is a set of circumstances that are affected by some legal framework or applicable legal rules. But does the position relate to the official within that set of circumstances, or does it relate to the person who's regulated, whose activities are regulated? Ostrom gave the example of a judge, and so she seems to be thinking in terms of an official. And as I say, that would seem to connect with the legal concept of power relative to an actor's role. The concept of boundary is, I suppose, a more straightforward, intuitively more straightforward concept, but aggregation captures something more complex, which is the relationship between different actors within social rule following in a commons, and who has the capacity to do what at different stages. So again, that seems to go back to the idea of a power, to the idea of being able to change legal relations. Two of the universal rule forms that Ostrom identified, choice and scope, these are also a little bit less intuitive because they seem to capture aspects of any kind of rule, rather than to be more immediately definable as a distinct sort of universal form in themselves. So there's some quotes here from Ostrom's 2005 work, in which he talks about these rules, participants and positions. He said participants in an action situation are decision-making entities assigned to a position and capable of selecting actions from a set of alternatives made available at nodes in a decision process. So capable of selecting actions from a set of alternatives. Examples of positions include players, voters, judges, buyers, sellers, legislators, police officers, and so forth. As I say, from a legal point of view, it's more intuitive and seems more, there seems more of a logical distinction to be made between officials and people who are operating within a set of circumstances affected by legal rules, where there's some choice to be made in what they do, or who maybe are some kind of bounded choice or regulated choice, or perhaps who are subject to some very specific requirements. But usually in the commons, you're talking about relatively voluntary kinds of behaviors or actions. So the idea of a participant relative to a position, from a legal point of view, seems maybe not as teased out or not as differentiated as it might be. Aggregation rules, going back to the idea of a power or a competence as the capacity to change legal relations, aggregation rules seem to relate to the overall pattern of power or competence rules, and in particular the idea of like you have in a federal legal system or a confederal legal system, that there are different levels of authority within a system. Okay. I just briefly referred to Ostrom design principles of governance. This is the third, if you like, the third aspect from a legal point of view, that's of interest to lawyers. Clearly defined boundaries, proportional equivalence between benefits and costs. I'd say I think the audience will be aware of this, very, very familiar with the design principles. One of them is graduated sanctions. So the idea that within an effective commons form of commons, the governance is marked by graduated sanctions for those who violate the rules in use. And this goes back to the element of relating commons rules to legal rules and what law might have to say about that. But within legal theory, the idea of sanctions as a defining law is controversial. It's generally accepted nowadays that legal rules do not always have a sanction, and that there are important aspects of legal systems that are not immediately associated with a legal sanction. On the other hand, there clearly is an overall element of coercion and sanction within how law works. So even if a particular legal rule is not associated with a particular sanction, there is in the background, within the framework of rules within which a particular rule operates, sanctions are at work and are central to what law is about. So one of the areas of interest from a legal perspective in commons research is think about how the analysis of rule forms and rule types and rule following within commons research can be helpful for teasing out the issue in legal theory about how sanctions define or not define legal regulation. I'll say a few brief things about the advantages of the institutional grammar, because that helps, I think, explain how a legal perspective can be helpful to it or can inform it. So one of the ways in which institutional grammar has been put to work is by allowing it to structure game theoretical analysis of how people behave given a certain set of circumstances or given the different variables within a game context. And I understand that Ostrom's research was not based on sort of some prior normative ideas about how people should behave. It was very much empirically grounded study of what happens in practice and how things work in practice. And she did laboratory work on the basis that if certain conditions were present, how would people act within that situation? And if you do enough studies of that nature over time, you can make generalizations about human conduct. So game theoretical analysis, predicting behavior, predicting what happens within certain when certain rule forms or types are present when certain elements of social cooperation are present. And trying to generalize from these studies to see what guidance can be given for the construction of commons practices. Comparative study of commons research kind of contributes to the same ultimate goal as thinking of general rules, general principles that indicate what works and what doesn't work within a commons framework. Identifying reforms. Ostrom used the analogy of a mechanic or a doctor to describe what a policy analyst, as she describes it, would do in commons research, identifying where there are problems, where rules are not working, and on the basis of this empirically grounded research on what tends to work in general in commons contexts, how a particular commons might be developed or reformed. From a legal point of view, the way in which commons research has developed and the way in which the kind of policy analysis that commons researchers apply works is to give you a comprehensive sort of coded map of rule types and rule forms. That can tell you, for example, what areas there is regulation, what kind of regulation there is in a specific area, and it can highlight perhaps gaps in a regulatory framework. Why is some practice, some set of behaviors within a commons context not governed by rules? Where rules don't work, what characterizes that set, that problem, that dysfunction? Can you draw from the idea of design principles and standard forms to maybe illustrate how rules could be reformed or added to? Okay, so one of the statements that you made about the advantages of institutional grammar is that why do this detailed work? And she refers to the fact that people were puzzled about why she was doing all this very detailed, sort of elaborate, maybe laborious study of rule forms, rule types, rule practices. And she identified these reasons: to work further towards solving babbling equilibrium problems for scholars doing institutional analysis. So babbling equilibrium problems are the idea that in any kind of social cooperative practice, there needs to be a shared framework of meaning, and that problems can emerge in these practices when people do not always have or do not consistently have a shared framework of meaning, and that studying commons practices can help, if you like, develop on this idea of shared meaning and avoid these problems of people what sometimes called in law talking across purposes, and contract law to be talking across purposes. To understand how action situations are constructed so that reasonable reforms can be considered. To move beyond slogan words to describe institutions. So the development of a standards vocabulary, a standard set of definitions that are clear, that are carefully teased out and applied consistently across different institutional settings. To cope with the immense diversity of rules by clustering them into 7 generic rules. So the universal rule forms are helpful for simply understanding what's happening in a commons framework, for getting some kind of conceptual map of what's going on when all these different kind of rules are interacting and working together. To look at rules as information transformation mechanisms. When you have a conceptual map of rule types, you get a much clearer sense of what's firstly what is happening, and then that can lead to studying what works well, what can change, what can be developed. To study the underlying universality of rules. So this basic sense or intuition that rule following is somehow fundamental to social practice, and that we need to understand either stand it further beyond just the basic sense of rules. Okay, Tina de Moor and her collaborators in 2015 published a alternative method typology of rule types in their study of historical commons in the Low Countries in Spain and in England. I think they're the 3 main jurisdictions, or the 3 main areas where they studied. So I've sort of abstracted the main elements of that typology here on this slide. So the first rule category you might describe as subject matter. I should add that in the first heading. So subject matter rules: access, use, management, and governance. Management and governance really go together, and I think they seem more sort of immediate, more intuitive than the universal rules that Ostrom lists. Or they're more specific to commons. They're more specific to, say, the kind of obvious examples of commons like land and water. Then Jean de Moor et al. Referred to the rule form. So the rule category in terms of subject matter, and then the rule form. So the deontic, permission, obligation, prohibition, appointment, rejection, or then the general category. The rule sequence, the rule party, the rule addressees, and then sanctions. So from that alternative typology, as I say, the rule categories are simpler. Subject matter categories seem fairly sort of straightforward. the deontic is highlighted a bit more, and sanctioning is highlighted a bit more. So what I want to think of is how might these different typologies be related to each other. Ostrom herself acknowledged the ambiguity and the complexity of position rules. Is it possible to combine the different typologies to see or to develop a typology that might be easier to use, maybe more elaborate, at least in some respects? One of the purposes of institutional grammar is to try to capture the detailed, complex reality of how rules work. So by having a more elaborate typology, or a typology that might be more intuitive or accessible for different users, perhaps that would be that would work in practice. I've never done any kind of coding. I've never done the kind of sort of the detailed analysis of particular commons and in practice. So I don't have experience with that. But it seems clear that what Ostrom was doing was trying to develop the idea of universal forms, and to do so in a way that was translatable and transferable, and therefore conceptual clarity, which she talked about when she referred to babbling equilibrium problems, the idea of having shared meaning. That avoidance of that kind of problems of shared meaning could be facilitated by having by elaborating on the typology that's used of universal rule types. Okay, on this slide, there's a list of a representation of Hohfeld's typology of basic jural relations. And Hohfeld divided the basic building blocks, basic jural building blocks into basic jural relation and the opposite and the correlative of them. So he started off with 4 basic concepts and then considered them in terms of the opposite of the concept and the correlative of the concept. And the 4 building blocks, if you like, the 4 most basic concepts were rights, privileges, powers, and immunities. Right is to be understood relative to its opposite and relative to its correlative. And the same with the other building, each building block, each one is to be understood relative to its opposite and relative to its correlative. So I'm going to say something about power. Power is the capacity to change legal relations. The opposite of power is a disability, an inability to do something under a legal rule. The correlative of a power is a liability. If somebody can exercise a power, that entails a liability on the part of somebody else to adhere to it or to comply with it. So part of what your Hohfeld's concepts framework, or his framework of concepts does, is emphasize the relativity of legal concepts, that legal concepts relate to each other. It's very hard to understand them in kind of atomistic terms. So a privilege is weaker than a right. Unlike with a right, there's no corresponding duty to obey or to comply with a privilege. A person may frustrate my privilege, but they're not under a duty to not do that, whereas they are under a duty to respect my right. What was if you like, what was Hohfeld aiming to do with his analysis? Well, one of the points he made was that lawyers sometimes do talk across purposes to each other, and that a lack of discrimination, a lack of differentiation in the use of terms like rights, liabilities, and powers, immunities, can lead to an incorrect legal result or an incorrect legal analysis or a mischaracterization of legal relationships. And he thought that lawyers could be more conscious of the exact ways in which they use these terms, and that would clarify legal analysis. Hohfeld is a very sort of venerable person in legal academic terms, but he's not this kind of analysis, that sort of approach to thinking about law is not very widespread. It's sort of marginal. It's seen as an academic thing. So even though he has this status standing within, say, within legal theory, it's not a sort of widely employed way of thinking about legal rules, because legal rules is based upon practice. and laws and different areas of the law seem to work. And most of the time, lawyers have a sort of rough idea of what they mean by the term right, and it doesn't cause problems in practice that not every lawyer might, comply with Hohfeld's clear conceptual typology. It may not matter all that much quite often in practice. However, Hohfeld's typology is kind of considered to be a classic statement within legal theory. Ostrom refers a bit to Hohfeld, but she prefers John Common's development of some of Hohfeld's ideas and his study of capitalism. Hohfeld uses slightly different terminology. He also doesn't distinguish so clearly between the legal or non-legal implications of basic concepts. So, for example, he prefers the term exposure to describe the opposite or correlative of a right. And the idea of exposure in Common's discussion of it includes any disadvantage, whether legal or not, that I might be put to when my right when my right cannot be put into effect or put into practice. So he steps outside a purely legal understanding of damage or harm, and that comes back to the idea that is it possible to think of a sort of a clear dividing line when it comes to social rule following between legal and non-legal rules. I don't think that that terminology was central to Ostrom's sort of analysis, but she did refer to it. All right, there's some other aspects of legal typology that are helpful for thinking about social rule following and different types of rules and universal rule forms. And in institutional grammar 2.0, there's been some elaboration of concepts that you can relate to legal concepts. So one of the distinctions that's been made in theorizing about rules is between constitutive statements and regulative statements of rules. Constitutive statements relating to rules that constitute a particular practice that is now understood to be bound by the rule. So they're sort of basic constituting rules of a practice subject now to rules, whereas regulative statements describe existing patterns of behavior and put them in the form of rules, but they pre-exist. They're not constituted by the regulative statements. So within legal analysis, within legal theory, there's a distinction between secondary and primary rules that come to be widely adopted. For example, it's widely practiced in international law. That distinction is between rules about the rules, rules about the creation of rules, the defining feature of a rule relative to a non-legal rule, rules about dispute resolution. So rules about the rules are referred to as secondary rules. Primary rules are conduct-related rules directed at, if you like, citizens of a legal system. And that distinction is quite helpful to for sorting out different kinds of legal rules, because it seems to accord to the actual practice of legal systems, that we have this practical division between the rules directed at citizens and the rules directed at legal officials. Another kind of norm typology within law distinguishes between different levels of norms within a legal system, and the idea that norms derive their validity from other norms, and that there must be a Grundnorm within, or a basic norm, that grounds the validity of other norms, and that this feature of producing norms based on a Grundnorm somehow distinguishes law from other kinds of social practice. And both of those ideas can be related to constitutive and regulative statements. So that's something that might help develop on the institutional grammar that relies on the constitutive regulative distinction for classifying, particular rule types. They don't map on so easily. For example, constitutive statements could be related to constitutional documents, even just at the level of terminology. But constitutional documents contain both, what you might call, organizational rules directed at the legal officials and fundamental conduct rules directed at citizens. So constitutions are taken to embody fundamental rules of both types. And this idea of, if you like, rules that are fundamental reflects a kind of normative hierarchy within legal systems that may be not so evident within a, if you like, more localized commons arrangement. But the more you apply commons analysis beyond, say, more localized commons practices, say, for example, with land management or with water management or forest management, say, the more you try to apply commons to geographically wider kind of shared resources or global commons, the more the idea of constitutional norms in a legal sense of having some kind of normative priority could be relevant. Ostrom herself acknowledged different levels of rule types, and she referred to constitutional choice levels of analysis. So she was quite conscious of what lawyers would call secondary rule types, constitutional rules. Within legal scholarship, as I say, this study of the formal conceptual character of rule types is not so widespread. But for example, the Swedish theorist Frändberg has written about different types of norms, and one of the more complex norms would be hybrid norms that seem to straddle the divide between primary and secondary norms that have some kind of what he calls ideological component to them.
Gerard,
Yes.
I just wanted to thank you so much for the interesting discussion. I just wanted to let you know we're about 12 minutes out. If maybe you wanted
Yes.
to offer any critical thoughts, maybe we could also just take some questions.
Yes, I'll just finish up and then I'll finish up, and then in the next 2 or 3 minutes, and then I'm happy to have discussion and questions. Okay, so in the last 2 slides that I go through, the first one here is to relate Ostrom to Hohfeld's typology, and how easily translatable to Hohfeld is Ostrom's universal rule types. As I say, the first 3 of Ostrom's rule types could be related to the term power. In this slide here, I've related the second one. The second one is related to right. You really could relate boundary rules to both the concept of power in law and the idea of a right. Boundary rules must be determined by somebody, the official, but they're directed at an addressee. The addressee of the boundary rule is the person who may get a right from that rule. Information is a subject matter rule that could have any, could have any kind of jural form. So there could be a right to receive information, there could be a duty to provide information, there could be a power to provide information or to withhold information. So it's possible to relate Ostrom's concepts to Hohfeld's basic building blocks. I think if you think of the subject matter form of rule distinction that the Moor uses, it's probably easier to make that translation. Okay, so I'll finish off with this slide, which is to suggest an alternative typology of rule types for studying commons, one that might be more intuitive or easier to employ. I don't know, because I have never done the kind of commons fieldwork that maybe many of the people here have been involved in. So firstly, to think of organizational organizational rules, governance and management rules, to use de Moor's terminology, or secondary rules, to use Hart's terminology. How is the commons organized? The governance, specifically the governance of the commons. So this would be to relate the idea of position within Ostrom's typology to competence or power rules in law, to rules of change and to rules of adjudication. Within legal analysis, within the classic statement of the idea of secondary rules associated with Herbert Hart, competence is not listed as a secondary rule. But I think it is helpful to think of it as in terms of secondary rules, partly because of its concern with what the officials do. So I think it's helpful to simply include it under organizational rules. Having thought about organizational rules, the next subject matter would be, again, following the Moors and our collaborators following their distinction, to think about the subject matter, the primary rules in legal terms. So what specifically does a rule do about the commons to which it applies? The right to exit or enter, to use the commons in a particular way. Are there information requirements within the commons practice? What kinds of rules about, well, payoff is the term that Ostrom used. What kinds of rights to be paid or liabilities to pay are there? And then a third category of more general subject rules. As I say, choice and scope are rule forms that Ostrom identified, but they really are features of any rule. So they're not very intuitive to apply as, if you like, distinct rule forms. So simply having an other duty imposing rule, a generic action rule, that doesn't fit into one of the either organization or standard subject matter rules, as another way of expressing a choice rule. Scope rules in Ostrom's scheme relate to outcomes. I don't think that there's any equivalent in law because within legal theory, because law by its nature has a deontic to it. It's concerned with how you do things rather than with outcomes. And now there are some exceptions to that, where legal rules will require an outcome to be achieved. There's an example within EU law, but it's not recognized, if you like, within legal theory. So maybe this concept of scope or outcome related rules is something that legal theory could learn from Ostrom's rule type and could characterize that kind of rule more fully than is often done. And Frändberg's work, for example, does seek to do that. Okay, because I'm conscious of the time, so I'll just leave it there. And so what I go my concluding slide. In this slides I've tried to apply this approach or the different approaches to the Outer Space Treaty, to characterizing the rules in the Outer Space Treaty, as a way of sort of applying it. Okay, so what can legal concepts contribute to institutional grammar? Well, conceptual clarity. Secondly, the organizational dimension is expressed more clearly. Thirdly, it's more intuitive. It's mostly relevant to the deontic element in Abdico and to the idea of rule types. That's especially what legal analysis can contribute. The primary and secondary rules distinction is helpful for bridging the different commons typologies. The organizational rules, as a sort of another way of expressing secondary rules, is probably helpful, especially for non-lawyers or people not familiar with some of the terminology. Another organizational dimension that can be helped is legal concepts of constituent power, the original constitution, and the levels within rules of change. I haven't had time to say much about that, and it's something that is in the Institutional Grammar 2.0. But I do think that legal thinking about constitutional rules and constituent power is a helpful way for teasing out the different levels within constitutional rulemaking. And finally, the deontic character of rules can be expressed more fully in using legal typology. And Cyril, for example, described the deontic power as somehow essential to an understanding of human social behaviors, and legal typologies can contribute to that aspect of it. Okay, thank you.